toehold that I believe does give us an argument, at least, for the court to consider and rule upon. No inmate has a legitimate expectation of privacy in phone calls in which he is engaging in illegal activities on that phone call. But that doesn't mean he can't have a legitimate expectation of privacy in conversations with others who are not his lawyers and not his spouse about his pending case.
Another thing that came up in Deputy Britt's testimony is the fact that this is a privilege when you're in jail. They're not required to give you access to telephones because you're confined pre-trial. And there is absolutely no right to talk on these telephones at jail. It's a privilege and a courtesy given to defendants. Some defendants choose to use it, while other defendants choose to not talk on the telephone. Thus, the jail calls should not be categorically excluded based on due process grounds. Also, we don't believe there's an equal protection issue here. The due process clause and the equal protection clause of the federal and state constitutions, they protect only rights. They do not protect mere privileges. And we contend that that's what we have at issue in this case. There's actually a case, Woodard v. Lawrence County, Site 265, Georgia 404. That's a 1995 case. And the court there said that the due process and equal protection clauses only protect rights. They don't protect privileges. And here there's no right to jail calls. There's just no right at all to it. It's a privilege.
Interesting argument. It may not be the right to the phone call, but the right to the conversation, maybe the way the defense would come back on that. But the spousal privilege, I would think would go away if you know that someone's listening to your conversation, right? Isn't it supposed to be communications that other people aren't listening to, but if you allow someone else to listen to it because you know someone's monitoring the call, then maybe you waive that spousal privilege. I don't know. Just spitballing here tonight, Julia. So where did the judge leave it on this issue today?
He left it where he left most of the motions that we've heard over the last 2 days, and that's he's taking it under advisement. So he's heard the arguments on this issue, and he will likely write a written order that we are going to be paying attention on the docket to see what he decides on that request to exclude all the jail calls.
Okay. And it's not necessarily a super easy issue. I mean, the defense has come up with some legitimate arguments, and we'll see what the judge does. More arguments today about the mental health of Ahmaud Arbery and whether that should come in. Let's take a listen to those arguments.
The experts' conclusions lacked sufficient probative value and thus were inadmissible under 403. Obviously, we are not there yet, but my concern is that Mr. Sheffield just told the court that one of the things he wanted was to put his doctor up in order to have you listen to her as part of the ongoing sealed sort of package. The state would object to her at this point testifying, given we're bifurcating this issue. So the court, though, however, the state wishes the court to be aware that 403 analysis is an appropriate analysis to conduct, because in this case, the court said, because of the rather raggedy patchwork of sources that the person had to deal with, I will direct the court to the raggedy patchwork of sources. These sources are Mr. Arbery's worst days of his life. Absolutely, the worst days of his life when he is involved in law enforcement. This is not every day of his life. And to have their doctor come in and go, well, I looked at all this stuff, and it supports a conclusion based on a 2-hour form that got filled out as a diagnosis. The state contends that's a raggedy patchwork of sources that their doctor had to work with, because their doctor never ever met Mr. Arbery and never talked to him on his best day.
The state has chosen to get into the mind of Ahmaud Arbery suddenly and say, well, these are just his bad days. These are just his days. Over the course of 3 years, which shows a very sad